You're listening to the Valley Current.
Like, should be in this? Should be in this? Like, is the other guy is, well, he's not low. 4 others. 40%. They're not even 50%. There is some money in fact. Like, should be in this deal as well? I mean, it's like a law school exam with,
who's in control of?
Lynn's in control, but he's a minority player. His view is his deposition testimony was, I get the consensus about everyone, all 5, before doing anything. That was his deposition testimony. It's an equal partnership. The money gets dispersed after everyone agrees. I mean, it's the really interesting question of what discussions have these guys had, right?
Yeah.
Because
it
look,
would be a lot easier if they could all get together and just come up with the $3 million.
Well, you'd have to give them an incentive, and the incentive would be along the lines of, you're going to get a huge discount for cash, and you should go to a hard money lender for the cash, right?
Yeah, if they can get somebody who's interested in doing that. That's the big question, right? I mean, I would think that if they're serious and they could get somebody to do that, they'd do it. But that's a lot of money.
It would cost an extra $500,000 to get that to happen. What would happen?
Well, if they could get it to happen at all.
No, they could get it to happen. If the real estate is there, they could get someone that would take the equivalent of $4 million worth of that real estate.
But we don't really know how encumbered it is. That's the thing that keeps bothering me.
Right. That's the hard money lender, special counsel, spending $50,000 of expenses that goes through all this stuff and says, let's make this happen. Right. It's like very, very detailed, gritty collection work designed to say how good or how bad are these assets, what liens are there. Because look, there's even something conceptually like an attorney lien that could be applicable here. That's not a normal lien. It's like a judicially imposed lien. Who knows? Like, you'd have to do a search right now to see if one of these lawyers has filed suit against any of these clients. That's possible. I mean, that could be happening right now, right? So it's a long-winded way of saying that, you want to slow the client down. He's obviously, sounds like he wants, I thought it was a mistake for him to be directly dealing with this guy to begin with, but he obviously decided to do it. He obviously thinks he's gotten a great outcome. I don't know. Do you think he's gotten a great outcome if the money gets paid?
Yeah,
if we get
absolutely.
Yeah.
Go ahead, Kim.
Yeah, absolutely.
He gets the $3 million.
Who gets on settlement? Who gets the full amount of a judgment ever?
Well, a lot of people would say the answer to that is a judgment that arises from an arbitration that's not really reviewable on appeal. Yeah, usually you get that. Usually you get collection of that plus interest. But yeah,
right. But I don't have any data points on that. I just know in general, you don't settle for the full amount of what you owe.
Yeah. And I mean, again, it's not like that's the only money they've gotten out of it. I mean, they also got $2.6 million before based on restitution and insurance proceeds. So they're ended up with $5.6 million. Now, I don't know how much they paid in attorney's fees, but that still seems like a decent outcome for what they really lost.
Right. But you worry at all that this is just beginning the negotiating process in the sense that, yeah, we sort of are agreeing to 3, but when a year goes by, we're going to say, we came up with another 1. Would you discount this yet again? Right?
Well, yeah, I mean, you always worry about that, but that's why your idea of if there's a hard money lender and we just get the cash, that's the best of all possible worlds, of course.
Right. Right. Because let me just tell you, the thing that probably sounds unthinkable, there actually are firms that would say, we're not doing the settlement for you. Get one of your other many law firms to do it. We're going to stay independent in the litigation, and we're not going to be we haven't really been part of this settlement. We haven't been part of the negotiating process. We're not.
Why? What would be the reason for that?
There's too much risk in this. There's too much risk that you'll later come back and be an undelighted client because you didn't collect the $3 million. So go get an expert bankruptcy person to implement this, and we'll just stand down and wait for whatever decision you make. I mean, I'm not saying that in a snotty way or in a resentful way. I'm just saying that when you see stuff like this, where the locomotive is steaming down a track, that you start to question whether it's going way too fast and way too many concessions and way too much stuff that's sort of out of sync with reality. Maybe there's a sign there that it's time to get some new player in who says, look, you really have to do some kicking of the tires here. Your point, Kim, that let's get the real estate title reports, but that's just a drop in the bucket. Like, how about getting full disclosure of all their assets? How about getting their tax returns? How about getting some real disclosure of how good was the punitive damages case that you're giving up? What if you find later they were sitting on $50 million worth of Bitcoin? Would that change your mind? What if it was provable that that was as a result of using the stolen proceeds? Right?
I guess in my mind, a lot of those things are, some of them are real what ifs, but most of them are just what ifs that are never going to happen. And you can't button it down so tight that there's never going to be any way out of it. I mean, you just can't.
Yeah. No, but I can see an independent lawyer saying, we got to get reps and warranties. That's the other thing that's not in there. Reps and warranties about their assets, right? Or reps and warranties about they really only have the real estate, but we know they have more than just the real estate, right? Don't we?
Yeah, but Jack, I guess you've told him all this stuff. He wants to go forward, so I think we ought to just figure out what we're going to do. And
just do it, God damn it, and stop talking about it, please.
Well, yeah, I mean, you're basically worrying about whether he's making the right choice, but you've already advised him on all this stuff, and he's not like a client who's naive or something like that. I mean, he knows what he wants.
In fact, the subtext from Diane was like, if we collect half of this $3 million, we're going to be happy.
Right?
Did you hear that? She said,
that's right. So she doesn't care about the future.
Yeah.
Maybe she's leaving the firm.
You collect 1.7, I'm happy. God damn it. Let's just move on. I mean, that's like to me, it's like they're fed up with this. This is like, we've had enough of this case.
Well, I think the other thing too that's going on is I think John feels vindicated that he showed these guys that they made a mistake by not cooperating with him. And, I mean, he's punished all of them. I mean, even if those other two guys don't pay another dime, I think they've still been punished in a way that they could have easily avoided if they had been halfway rational from the outset. Well, I mean, after they got caught.
Let me ask you, what would be the presentation? Just assume all the legal paperwork gets done perfectly. Hard to imagine, but let's just assume. Hard to imagine anyone getting it 100%. Let's pretend it does get done perfectly. What's the statement in front of Judge Kumar? What's the statement?
What do you mean by statement?
What's the agreed joint statement of what happened? Like what happened? What do you guys want? What do you want from me?
Well, I don't think we want anything from them, do we?
Okay. Well, I need to know scheduling. I need to know.
Well, if we have an agreement, I mean, it depends. I mean, it depends on what the agreement is. But if we did have an agreement that it's $3 million lump sum, and everything else is released, then we would tell them, thank you for helping us. We've, in light of your interim award, we've reached a settlement agreement. I think he'd want to see it. I don't see any reason why he couldn't see it.
So
that's it.
You're closing down the case as against all defendants, even those who haven't signed your judgment.
If that's the agreement.
Okay.
Yeah. If that's the agreement. Now, if that's not the agreement, then we would say.
I don't think that's the agreement. I think John wants to keep a cloud over the head of Deke and the others and just basically wait to see if performance happens. I do think, Kim, that he and are shutting down if they get whatever deal they get. I think they're going to say no further work.
Well, I think what we ought to do.
They can't have it both ways.
Yeah, I think what we ought to do, if we did get the agreement and they want to keep going after the other two or three, although one of them is absentee, that I think we serve the discovery on them to get all their assets, their tax returns and everything. And then let's see if they still don't want to settle. And I mean, how much of a hearing do we need with these guys? All we really need is to put on their finances, their net wealth. The judge already thinks they're bad guys. We don't need to go back and try to prove that again. We could probably do it on paper or have an oral hearing with them. We don't really need a lot more evidence, do we? I mean, if we wanted to just do it on the cheap, and they're going to be at risk, and he's probably going to hit them with some punies, maybe not a lot, but he's probably going to hit them. I mean, why do we need to make a big deal? As long as are okay with kind of doing it on the cheap, I think we could do it without without expending a lot of money.
Okay, so then these remaining defendants say, we want to have you hear what exact settlement deal was made with, and because they obviously gave up the punitive damages against the biggest fish that are out there and make whatever deal they may. Doesn't that negatively affect our case?
I don't think so. I think it basically says we settled with them because they knew there was a potential of punies coming down the pike, and we made a deal with them so we get paid. And these guys didn't want to join in, and so even if he would look at it in a way that says I'm going to credit that whole $3 million against actuals. Okay, so these guys don't have to pay us any more actuals, but that doesn't mean they shouldn't be punished for what they did.
Oh, that's right? Good. But let's take John's view that we divide it as half actuals, half punitives.
Right.
And actually put in recitals that's part of this anticipated settlement. Is that a good signal to the judge that we effectively came up with a formula for punitive damages? Like we actually put their net worth is north of some number. Or does that give him a formula that he can use against the much reduced net worth?
I don't think he's going to care about any of that stuff. I think he's going to say, okay, you settled. I'm looking at this settlement agreement. Obviously, there was a big fear of punitive damages here. And whatever you guys did, you did. Congratulations. I'm glad you worked it out. And then he's going to look at the other guys and say, okay, so you guys aren't settling, then I'm going to go to phase 2 and I'm going to issue my word against just the two of you. And I mean, they can't, even if they could say that the $3 million is creditable towards their actuals, that doesn't reduce the amount of penalty that they should have based on those actuals. He can still award punitive damages against them using the $3 million from his award as a lodestar.
Okay. Let me give you one last angle that they take. And were really the movers and shakers in this deal. They were the smart guys in the room. They've now settled. We were just their pawns. We were just used by Ken and by Lynn. They've since come to a settlement. Whatever the punitive allocation was made, you shouldn't harm us because we have them testify in the phase 2 Yeah, we made a deal and quickly because we were the movers and shakers. All the previous stuff about equal partnership, 2020, yeah, that was just a facade. It was really calling the shots, and really was just a puppet, as was they were just soldiers in the army.
You want my reaction to that?
Yeah, that happens in phase
My
2.
reaction is nice try. You're still going to get punished. You're adults and you shouldn't have committed fraud.
Okay.
Yeah, I don't think it has anything to do with the punitive damages award. I also think that they would be perjuring themselves given the testimony they gave at the liability phase. So
Right.
I don't see it happening.
Yeah, that's a good point. They've already taken a position. Now they're going to come back and say, "Well, we weren't telling the truth, but don't punish us." Well, we were lying, but don't punish us because we.
Well, don't assume that there won't be some new spin, because I see this as a very organized, concerted effort, and I think they're even using to some degree, as the old man can say anything and then backpedal away from it. Like,
I don't know. I think you're giving them too much credit.
No, I think I'm giving them a lot of deception as part of their game, and it's part of their game plan. And Jinkerson is like, yeah, I'll have the discussions. They're willing to have John talk directly. I'll play it out and try to get us some options. And it's all just optionality. There's nothing real about it because they haven't signed the standstill. They haven't withdrawn the latest motion. Do you have cycles to write the 3 to 5 points that can be written about these rules and why, at least procedurally, Joe, this is not correct, this motion?
I can work on an opposition to the motion.
No, but I think we should write something like it should be immediately stricken, or if there's going to be a briefing, then the briefing should be, I guess the next 30 days so we can keep it hanging out there while all this deal paperwork is done. I mean, it's going to screw us on scheduling the phase 2, but the phase 2 doesn't sound like it's going to get scheduled anyway, right?
I think we ought to just my preference would be just to put together an opposition brief with those points and also the backup points that. Wouldn't you want to make backup points too? That he's already considered the evidence, and but you want to just be purely procedural.
Well, I wanted to be purely procedural to get something out before the 19th or whenever he's going to hold this hearing.
Oh, okay.
But the idea would be that we reserve our rights. That he wants us to go and pick through the transcript and underscore all the exhibits and all that jazz. I probably would be like, look, that's not appropriate, but if we're going to do that, we should have 30 days to draw every negative inference that we can against their testimony, because that's really the way to get support for this ruling. Right?
Why would we give him that option if we're saying that it's a procedural no-go? Then that's how we should treat it, unless he comes back to us and tells us that he's gonna,
Well, it's like a footnote to say that if he disagrees with us, then obviously we need to kind of go through the whole transcript, blah, 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 and decide whether we want to put together a ginormous book for him to read. I would just hate for this thing to get lost because says, oh, you didn't reserve the right for us to go back and nitpick this transcript and every inference from their half answers and so on, right? Because there was stuff where there was some potential for drawing adverse inferences from them and from what they did.
Well, why doesn't Taylor get on that research then about whether they have any right? I mean, beyond the rule. I mean, I can argue off of the rules, and yes, I can.
There's a lot of case law, Taylor, about it's really face of the award kind of error.
Okay.
There's a lot of case law on this. You don't get to go into the notepad of this arbitrator to figure out, relitigate the thing. It's really designed to say, and the only exception I would say, I've not seen it, would be if the fact that he wrote that statement, look, if anyone's got an objection, tell me what it is and I'll pick it up with you. Maybe that opens the door to, he set a different procedural rule, but he signed the interim award. He should have just sent it unsigned saying it's a tentative and I'm going to let you guys argue it. He signed it like it's my.
Did he say that in his award that we could make a motion?
Yeah, there's a sentence at the end of it that's like, if someone's got comments about this, I'll take it up within a week. Isn't there at the very end?
Yeah, it says
Explanation.
to the extent that any party seeks further explanation of any omitted issue, they should request the same in writing within 10 days of the date of this interim award. So he's saying seek explanation of any omitted issue.
Yeah, that's.
He's not saying that, they want to challenge it.
Right. So you got to read that along with the rule as saying it was still 7 days for the rule as to typographical errors and the rest. He wasn't superseding that. He was saying he's going to give 3 more days. He was giving 3 more.
No, he's just quoting the rule. He's just quoting the rule 24H is what he's doing.
Well, then
That's
what's
just
the rule that says 7 days?
Well, this is 24H.
Yeah, 24H, yeah.
Right. Which one is it 24J? What's the rule that says 7 days?
Hold on. Let me try to how do I get back to my.
Because he should have actually quoted that as well, right?
Okay. So 24H. Well, what the hell is he quoting? That's not what he's quoting.
Quoting a different version of H.
No, he says that. He says that as well. And then.
Is that the latest version of these rules?
I thought it was. I downloaded it.
I think what he's saying is he feels that he complied with his duty to make a written statement on every issue. Tell me if I didn't.
Yeah.
Is comprehensive rule different than, please note that GM's comprehensive rule 24H.
No, it's all, I mean, what's on the very end of page 15 of the award is 24H verbatim. And then he has this additional sentence to the extent that any party seek further explanation.
I see. So that looks like it's part of the quote, but it's not. It looks
like it's part of the quote, but he also, he has it. It kind of has this like highlight that it looks like it's part of. It's block indented too, though. So
he cut and pasted it from some other award. That's my
probably. And I just think his point is, I think I've done my job.
Yeah.
I've looked at every issue, which is the only thing I have to do. And I've given you a written statement on every reason for the award, which is the only thing I have to do.
Right.
If you don't agree with me, tell me.
Right. Yeah. And further, I'm not extending J. I'm just telling you, I'll give you 10 days, but they're going to say they were misled by that.
And he's not even saying if you don't agree with me. He says, if you want further explanation of any omitted issue.
Yeah.
Yeah, there's no admitted. No, okay, I can deal with that. Yeah, all right. So that's not a
quote. Is there a lot of research to do on this then?
Find the cases that deal with deal with the rule that talks about typographical and computational errors are really what the judges say is on the face. Anyone reading it would be like, oh, this judge didn't add the numbers. Oh, this judge didn't use the right word here. Oh, this verb tense is out of sync. This grammatical.
Technical.
They're
changing the substance of the award.
Yeah.
That's what they're trying to do.
Yeah, but Jack, I know that I know there's case law on that if you try to object to the award in the Superior Court, but this is a little different. This is still within arbitration.
Right, but you might see some case law that talks about the arbitrator himself, once he issues an award, can't do it.
Okay, well, that's what you need to look for, Taylor. You understand the difference?
Wouldn't they have to, essentially just try to appeal this to the Superior Court?
Yeah, but it's the same test. Like, in other words, if you look at what happens during arbitrator training, they actually will tell you when you get trained by any of these organizations, look, once you issue an award, stand your ground, because being wishy-washy is the worst thing in the world. Yeah. Like, it really should be like, if you look at the argument, they're asking for reconsideration. What's the new law and what's the new evidence? Like, if there was a declaration by, say, the Wang saying, but we paid them back and they lied to you, there was a fraud on the court that occurred because we paid FFN back. that would be some new facts, right? That's not in this case. Or if there was some new law. I mean, I haven't read their new stuff. Are they making some statute of limitations argument, or what are they?
I just glanced at it. I didn't see statute of limitations. Basically, what they're saying is it was not part of our complaint, and so it's really beyond what should have been litigated, and we didn't move to amend and conform to proof. That's what I got out of a real quick read.
But didn't we have it in our brief and everything? I mean, we covered it, right?
Yeah, but they in their defense, they did make a motion in limine that basically said the same thing, and he denied it. So, I mean, I don't think we can really argue that they didn't make that objection in the hearing. So, I mean, I think, though, that, maybe this is something, this gets more into the substance, though. So maybe I'll give this to Taylor after he finishes the first round. But I think under the CCP, I think you could make a motion to amend after judgment.
I don't think in arbitration you need to do it. We're not, unless you say, well, this is all this, his nutty version of the CCP rules apply to all this, right?
Well, what's an arbitration? What bounds and what bounds what can come in an arbitration?
The opening brief.
The opening brief?
Yeah, unless there's a case management or pre-trial conference that says these are the exact issues, the opening briefs on each side basically set forth what parties are presenting.
Can you find that too, Taylor? Can you find something that says that?
Probably something even in the rules that talk, even in the arbitration rules that talk.
Well, I'll look in the arbitration rules, but I mean,
the gloss that's problematic is Comar's gloss that we're following the CCP throughout, because we really didn't. Yeah. Like he wanted to say that we did. But the reality is that pleadings are not hard and fast in arbitration. They're just not. Notice of claims. Didn't we have something in the original filing?
Well, we filed an amended complaint.
And we didn't have that in there? We didn't have the Wangs and the Lees in there?
No. I don't think so. I'll go back and look. But
oh, we did.
No, I don't think so.
Each party shall afford all other parties reasonable and timely notice of its claims. Any such notice shall include a short statement of its faction, no claim. Well, that's our notice. Our notice was our opening brief.
I mean, there was no doubt that we were pursuing it because there was testimony about it.
Right.
I mean, they just didn't take it seriously and now are just, kicking themselves about it. That's the reality. But the
reason the filing claim, the party may make a new or different claim. Such claims shall be made in writing, file with JAM. So we that's our brief. Oh, then there's this, of course. That's not good. Oh, well. We'll figure something.
I think once it's in the case, it's in the case. And I think that if they are turning it into something bigger, I got to take this next call, but I think if they are turning it into something bigger, we should.
So are you doing the thing for the...
Yeah, I'll do that. Why don't you do the procedural opposition with a footnote?
All right.
About substantively, if it's really going to be retried, then we want to have a whole retrial case or whatever, but that's kind of a crazy footnote. But just block a footnote that hints that if this procedural objection doesn't work, then we got to do something far bigger, which is crazy.
All right.
All right. Talk to you guys later. Thanks very much. Bye. Bye.
Tune in next time on The Valley Current.